And as Omar mentioned, the jury of 9 women and 3 men will continue deliberating the charges this morning before breaking for Thanksgiving tomorrow. So joining us now to talk more about what they face today is CBS News legal contributor and former Manhattan prosecutor Rebecca Roiphe. Rebecca, thanks for joining us today. The prosecutor had the last word yesterday and honed in on the jury to say that even though Travis McMichael shot and killed Ahmaud Arbery, Gregory McMichael and William Ronnie Bryan are just as guilty of murder. Could each of them be charged differently once this case is over? Could they be convicted of different crimes?
They absolutely could. So as Omar was explaining, the judge already suggested that William Bryan could be found guilty of lesser charges than the other 2. And that indicates that all 3 of these defendants were in slightly different positions, especially William Bryan, who was called in later and came and filmed the incident and then used his truck to help box in Ahmaud Arbery. So it is possible. However, that murder charge, the felony murder charge, makes it such that even though these defendants were differently situated, it is possible and in fact likely that if the jury finds that any one of them is guilty, then they would all be found guilty. And I'll just take a second to explain that charge. Felony murder is essentially a charge that says, if you're involved in a felony and you cause and somebody's death is caused by one of the people engaged in that felony, then everybody engaged in that felony could be guilty of murder. So that's significant here because obviously only one of these defendants pulled that trigger. But if all of them are found guilty of engaging in, let's say, aggravated assault or false imprisonment, then, and one of them obviously caused the death of Arbery, which isn't in doubt, then they all could be found guilty of murder.
The jury will meet again to deliberate today, but we heard that they will be off for Thanksgiving. There was some speculation as to whether or not they might feel some pressure because, it's a holiday weekend coming up. They're going to have to be right back at it on Friday. There are all sorts of things that juries take into account, but they're also human, and maybe they miss their family. Maybe they didn't have Thanksgiving dinner last year with their family. Do these elements, do they sort of provide more pressure on a jury? I know you're sort of speculating, but I'm wondering if that's something that legal analysts consider.
Well, absolutely. I mean, if you're a trial attorney and you're coming up upon a holiday weekend like this one, and the jury is facing additional days of deliberations after the holiday here, Friday and Saturday, then certainly you're thinking to yourself, this jury wants to come to a conclusion today. But, I wouldn't hold my breath because, of course, this is also a jury that's taking this very seriously, and they've been told by the judge to take this very seriously, and they have to look through a number of complicated charges that have a number of complicated elements, and they have to all agree on these charges. And so, I don't think they would take it lightly. I do certainly think they're feeling pressure, and if they could come to a resolution today, they would come to a resolution today, but not by cutting corners.
Earlier we talked about the makeup of the jury and the fact that there's only one black individual on the jury. And there was some debate about, and I hope I'm saying this right, is it peremptory challenges, that allow, attorneys to sort of summarily dismiss a juror. And some suggest that they are sort of innately biased. Can you kind of talk about what that legal argument is?
Sure, absolutely. So you have a constitutional right to a jury of your peers, and that is, what does that mean, really? I mean, what is a jury of your peers? Well, what it really means is you have a right to a set of jurors who aren't going to be biased against you, and your attorney uses these peremptory challenges to help create a jury of your peers, a group of people who won't be biased against you, and you're allowed to, look at some factors to determine whether you think this person might harbor biases against your client or, against the government if you're the prosecutor. And that's fine, but there are certain limits. One of the things you cannot do is choose your jury based on racial considerations, and that was the concern here. But because there's this countervailing concern about a jury of your peers and being able to pick a jury of your peers, we don't just assume, because of the jury's makeup, that the defense attorney is using his peremptory challenges in a biased way in order to get rid of jurors of a certain race. And so the way it goes is, if there's a reason to believe that he might be, the other side can raise that question, and then the judge will look at it and say, yeah, look, on its face, it looks like you keep striking, let's say, African American jurors. And then it goes back to the lawyer to give a non-biased reason. So he can come back and say, no, I wasn't striking those jurors because of their race. I was striking those jurors for completely legitimate reasons. And as long as you have a legitimate reason, that challenge, which is called a Batson challenge, is not going to survive. So it's pretty hard to establish that a lawyer has been using his peremptory challenges in a racially biased way, because that lawyer can always come back, and as long as he can find one or two reasons that are not biased, then that's where the inquiry stops. So the mere fact that there is only one black juror may have raised a question, but it doesn't end the inquiry. And here, the lawyer was able to say, here are some reasons why that have nothing to do with race, and so all good. But, it's a consideration, it's a concern, it's a very difficult issue when it comes to trying cases like this.
Yeah, I know I'm going to ask you to sort of reach back into your memory crates here, but I thought, reverse Batson, is it ever successful? Because you can always figure out another reason as to why you don't want a particular juror on the panel.
It is sometimes successful. There certainly have been successful Batson challenges because, at a certain point, it looks so, whatever your reason is not sufficient, or it can be shown that you didn't use that same reason to strike a different juror. There's inconsistency. So it can be established, but it's hard. And it's hard because, you can usually come up with some reason that will fly. So yes, they are sometimes successful, but again, merely showing that there's some racial imbalance in the jury is not gonna do it.
Yeah, Rebecca Roiphe, great talking to you. Thank you.
Thank you.